SJC-11554, Commonwealth v. Kevin Quinn.
Yes, good
May it
morning.
please the court, Eric Brand for Mr. Quinn. Your Honors, this is an appeal from convictions of rape of a child and indecent assault and battery on a child. The appeals court affirmed the convictions, and the case is here on a grant of the defendant's application for further appellate review. The sole question for the jury at trial in this case was the credibility of the complainant's allegations, whether they were true or whether they were fabricated. Now, in our application for further review, we stress two issues that go directly to the question of the complainant's credibility, and which, in our view, the appeals court analyzed erroneously, and those are the issues that I'd like to focus on this morning. First, there was the testimony that the prosecutor elicited from an expert in sexual abuse that implicitly vouched for the complainant's credibility. And secondly, there was the fact that this testimony was elicited from an expert who had been the complainant's own therapist, who had treated the complainant as a patient.
Are we reviewing under the substantial risk standard?
No, Your Honor, these,
He preserved the objection?
that's what I was,
Isn't it both? I mean, one of your objections was preserved and one wasn't?
there's a third point that deals with express vouching. We acknowledge that was not preserved. The 2 points that I plan to discuss this morning are both fully preserved.
Implicit.
Implicit vouching and the use of the complainant's own therapist as an expert. The Commonwealth makes no argument that they're unpreserved, nor did the appeals court.
Now, can I ask you, Mr. Brandt, I had not realized that this expert was an expert. You just said in sexual abuse. I thought she was simply her treating therapist. And
was a
she wasn't seeing her initially for sexual abuse, but seeing her because she was depressed and bullied and so forth.
That's true, and the defendant called this therapist as a fact witness to talk about some of the things that she had observed. The defendant did not use her as an expert. It was on cross-examination, so the first thing the prosecutor did was qualify her as an expert.
As an expert in sexual abuse matters, or as an expert
yes, in matters
how?
of in treatment of sexual abuse, someone who knows all about
Did
victims
the,
of sexual abuse.
did the prosecutor, when you say qualified it, explicitly ask the judge to recognize her?
No,
as a-
Your Honor, but she, the prosecutor elicited testimony concerning her experience with victims of sexual abuse. She elicited testimony that she had had 17 years experience, and then asked her questions about, based on that really what it is based on her expertise and her experience.
But that part, you were the counsel was cautioned about, not the implicit vouching, but at least that would
I'm
happen.
sorry, Your Honor, I'm not
I thought
hearing
that part was the judge cautioned that if you do this, I thought there was a caution to counsel that there would be an opportunity to ask about the expertise.
The judge does offer that caution, and the appeals court emphasizes it, but it's a little hard for me to see what that amounts to, since if the caution is erroneous, then it
You just mean if you've got a fact witness, it's not open season. That's what you're saying?
no. Let me start here with the rule, the vouching rule that this court has stated for experts. This is in the Trowbridge case.
Just as a matter of curiosity, did the Commonwealth list this witness as an expert?
No, Your Honor.
This was a defense witness.
And
I know it, but did the Commonwealth list this person as an expert? Did the witness submit a bill for expert fees, and did it get paid by the Commonwealth?
no, they were just cross-examining. What they did was they took the defendant's fact witness and
Yeah,
converted her into an expert.
I understand that's what happened.
I'm not aware that they disclosed this in advance. I remember there was some discussion about the fact that the Commonwealth did not intend to call its own expert. And it was clear that the Commonwealth wanted to cross-examine this fact witness as an expert, because that's what defense counsel sought to present, that's what the judge allowed. So the basic rule here is that it's a black letter rule, black letter rule stated by this court in the Trowbridge case that says an expert may not even refer to the complainant. An expert in sexual abuse in this context may not refer to the complainant, and that means may not even mention the complainant, much less compare her characteristics to those of a typical victim. This appears in the Trowbridge case. It's quoted in the Richardson case and numerous other cases.
Aren't those all, cases where the Commonwealth called somebody and no question about it called the expert as an expert witness? It isn't this situation that where a fact witness called by the defense is then in cross-examination. And why shouldn't that make a difference?
Well, the cases show that doesn't make a difference, and I'd point the court on that point to the Richardson and the Rather cases, which are cited in our brief at page 26. Those are cases really just like this one, where the defendant called the witness as a fact witness, and on cross-examination, the Commonwealth converted the witness into an expert. And what these cases, nonetheless, the court found improper implicit vouching by the expert on cross-examination by the prosecutor. So basically, these cases show that this sort of expert testimony is not insulated from error merely because the defendant called the witness initially as a fact witness and presented some factual
But that really
evidence
goes
about
to your other point. It more goes to whether there was, in fact, implicit vouching rather than, I don't understand the black law rule to be against having someone who's also a treating physician be an expert. But there's a lot of caution against it because of the danger. And so the real focus here, as I gather from your argument and your brief, is that there was implicit vouching.
Yes, so let me address that, Your Honor. Here's the implicit vouching in this case was done by the technique of juxtaposition. And here's what the prosecutor did. She first elicited testimony describing the complainant's psychological symptoms. And this was a list that included 5 symptoms and included the memorable characterization that the complainant was, quote, very shut down, end quote. And then immediately after that, beginning on the very next page, she elicited an identical list of symptoms that the expert sees in typical victims of sexual abuse. The same 5 symptoms, also including the characterization that the typical victim is very shut down. Now, obviously, this juxtaposition presented the jury with a very pointed suggestion, and that is the conclusion of the syllogism that had been presented. And that conclusion is that this complainant was, in fact, a victim of sexual abuse. The complainant has these symptoms. The testimony is the complainant has these symptoms. A typical victim has these symptoms. Ergo, the complainant is a victim of sexual abuse. And the problem with that is it expresses the expert's opinion about this complainant and her credibility.
Now, if I can just get a sense as to what is permissible, okay? I gather it would be permissible for the Commonwealth to call an expert like Dr. Ireland and to ask her, tell me what the typical symptoms are of a child who's been sexually abused.
Yes, Your Honor.
And then through other witnesses, elicit that those symptoms are the symptoms that the victim suffered from. All that is fair game.
General characteristics is what the cases permit.
As well as evidence indicating that the victim had those characteristics.
Separate evidence.
Separately. So the only thing that is forbidden is to have the same expert elicit both, because that arguably suggests that this expert is saying she is a sexual assault victim.
That's right. And this is, as we see it, this is a result of is a line drawn as a sort of policy compromise. On the one hand, the court feels that the jury should be able to hear about the general characteristics of a typical victim of sexual abuse because it's viewed as outside the jury's common knowledge. But on the other hand, there's a danger, exactly the danger that you just mentioned. So on the other hand, we don't want the expert to dominate the jury's consideration, and we don't want the jury to think that she's expressing an opinion about this complainant. So the compromise is we let the expert testify about general characteristics, but she doesn't get to say anything about this complainant. And that's the reason that I stressed the Trowbridge rule in the first place.
Let me ask you about the prejudice.
Yes, Your Honor.
The symptoms that I think that were used here were depression and anxiety, I
There
think.
were 5 symptoms. Those were among them.
Okay. But were those symptoms, how was this developed in the course of trial? Because a lot of people are depressed and anxious about a lot of different things, totally unrelated to sexual abuse.
Right, but this expert is saying that those are symptoms of a typical victim of sexual abuse.
Okay, but the jury also would have heard that had this been done correctly by 2 different witnesses. How was it developed through either direct examination or cross-examination? Was there anything that did the defense counsel or did anybody bring out the fact that many people are depressed and anxious about a lot of different things?
I don't believe that was discussed as a general matter. Defense counsel elicited a few of these symptoms on direct examination because in the view of the defense, her anxiety and depression was based on
Bullying.
problems with the other kids at school. So this is why the defense elicited. The Commonwealth then, sure, they get to respond to this evidence. They get to rehabilitate their witness, but only with permissible evidence. And the permissible evidence in this area, which is the result of the policy compromise that I was talking about before, is the expert only gets to testify about the general characteristics of a victim of sexual abuse. She doesn't also get to testify about this victim's testimony, much less juxtapose this victim's symptoms with those of a typical victim, because it tends to convey the expert's opinion about this victim, and that is improper vouching because no witness is permitted to express an opinion about another witness's testimony. I think I've made the basic points that we wish to make. For these reasons, we'd ask that the convictions be reversed.
Thank you, counsel.
Good morning. May it please the court. I'm Catherine Semmel, appearing on behalf of the Commonwealth.
Counsel, in your brief, you suggested that there really wasn't a juxtaposition, or did I misread your brief?
No, that's correct. What happened was the prosecutor in cross-examination of Miss Ireland asked her about symptoms or the demeanor of the victim with regard to when she first met with her, and which elicited all of the things. She was depressed, she was anxious, she was shut down, she had had trouble sleeping, so forth.
And then within a page,
Well, then the prosecutor asked Miss Ireland about her background, which took a page or 2, and then she asked her about typical attributes of sexual assault victims. And so there wasn't a case where she elicited the fact that the victim was depressed and then asked the expert, is depression a symptom of sexual abuse?
Actually,
It wasn't.
there was a little bit about her background in between the going further and then speaking about this other symptoms. But didn't this really start, at least with respect to the cross-examination, with first establishing that she was a clinical social worker who worked with people who had sexual abuse and physical abuse, and then immediately after that, going over whether that now expert witness could describe what malingering is, which he'd earlier talked about on direct, and eliciting whether there was feigning and did she meet with her, and then based on that background of she's a sexual abuse expert, physical abuse expert, she knows what malingering is, then tell me, what did she look like, and then when you first met her, and now tell us about what it looks like if someone has been sexually abused. Isn't that what happened within 4 pages?
It did happen fairly quickly, but interspersed between the demeanor and the symptoms was discussion about Miss Ireland's background.
A little bit development, but that was really already established.
I'm not sure that but she certainly questioned her about her background. Absolutely.
How is this different than Trowbridge?
I think that this case is really about the right of the Commonwealth to a fair response. And I think that there are lots of factors in this case that go into determining in this case-by-case basis whether it was appropriate. But I think that's the single biggest factor, because this wasn't a situation engineered by the Commonwealth. The Commonwealth didn't call the therapist, elicit her symptoms, and then elicit
But you had an expert, I take it, who would have testified to the general terms of.
We were not presenting any expert testimony. There was no expert in the case.
She was not qualified as an expert?
We did not, in our direct case, we did not produce any expert.
I mean, in this case, you intended to use this person as an expert witness.
Only once she had been called by the defendant, and she had been asked specific questions which were designed to show that the victim's turmoil and emotional problems were related to problems at school. During direct examination, the defendant had a couple of purposes. Clearly, they called.
Let me ask it a different way. If you had called this witness, and asked this witness to testify to what symptoms she displayed, and then asked this witness what the general symptoms of sexual abuse were, would that have been different than Trowbridge? In your direct case, you had called this witness, and all of this came out in direct examination by the prosecutor.
I'm not sure that would have been different than Trowbridge. It might not have.
So it's different because some of it came up on direct and some of it came up on cross.
Right. It's very different because the point of the Commonwealth's cross-examination was that the defendant had called Miss Ireland to try to show that all of the victim's emotional problems during high school were related to her problems at school. This had come out anecdotally during the Commonwealth's case in chief during cross-examination of the victim and the mother, but then the defendant called the therapist to give the therapist stamp, I would suggest, to the fact that here's what the victim came and reported to me. She reported she was being bullied. She reported she was being threatened, that she was afraid to walk through the hall. She was grieving a friend, all of these problems. And here's her symptoms. She was anxious. She was depressed, clearly asking the jurors to draw the link between the two.
And wasn't there also a question posed on direct about whether or not she had ever reported sexual abuse to the therapist in all the times that she was seeing her?
That was the second component of the testimony. I think there were two main reasons why the Commonwealth called Miss Ireland. One was to establish that she hadn't reported the sexual abuse, although that came out in the Commonwealth's case because they asked the victim about it there too. And she acknowledged that she hadn't told the therapist until their last meeting. And the second was to explain why the victim was having all of this trauma during high school. And I mean, we don't even have to guess about it because there are a couple of sidebars where defense counsel very clearly stated when questioning was going on about the victim's problem at school, I do not want the jurors to think that her problems are due to these allegations. I mean, that clearly was the import of the testimony. So when she discussed with the judge what was going to happen if she called the therapist, the judge very clearly stated, there's no expert testifying right now. The Commonwealth hasn't produced an expert. If you do produce an expert who has qualifications to discuss attributes and you open the door to that kind of testimony, I'm going to allow it in. And I think that is exactly what happened. If Miss Ireland had only testified about the fact of the failure to report the sexual abuse, then I would suggest that our cross-examination would have been limited to failure to disclose, whether that's typical, all of these things. But that's not all that the defense did. The defense very clearly laid out, here were her emotional difficulties, and here was the reason for them. All of these problems at school, and that's all we discussed in therapy for 20 sessions over 8 months until that very last session. All we discussed were all of her problems at school. That's why she was troubled. So in that scenario, for the Commonwealth to come in then and elicit an alternative scenario, well, aren't these symptoms also consistent with sexual abuse victims, is, I think, appropriate. And the manner in which it was done was also appropriate. There was no linking. There was no opinion offered, and the judge was very clear, I'm not going to allow the expert to offer any opinion. The prosecutor asked, what are the typical attributes of sexual assault victims? She asked follow-up questions about them. For instance, when the therapist mentioned cutting, she did ask, what do you mean by cutting? But it was all designed to show an alternative basis for the theory that the defense posited in direct examination.
But the direct examination of this witness by defense counsel, it was a fact. She was developing facts, not expert opinion. Isn't that right?
It's difficult for me to draw the line between fact and expert opinion in this situation. Certainly, she asked her expert-type questions. She asked her questions about anxiety and so forth. It's true, she did not ask the specifically parallel question. She didn't say, well, is this consistent with a person who has been bullied? But that was the clear import of her testimony, and she didn't need to ask because it was in the evidence. Here's what she said was wrong. Here were her problems. She didn't need to draw the link. And I think that there are other instances where you call an individual, particularly in science, medically related areas, somebody calls an individual to give a fact question. For instance, a fingerprint analysis. You call the police officer to say that no fingerprints were adduced. No fingerprints were found. Fact question. What happens on cross? On cross, you ask them all kinds of questions. Is that typical? Can you usually get a fingerprint from this type of material? Things like that. I don't think it's very different from other instances where we, on cross-examination, have latitude within the person's expertise to question the basis for the fact.
But was it within that's the interesting question, though. I mean, was the defendant in the direct examination of the therapist asking for any kind of opinion or anything having to do with expertise, or was it simply to elicit what in fact had come out during therapy sessions?
She asked her, in-depth questions about basis for anxiety and depression, agoraphobia. She asked her questions like that. She didn't ask.
Did she ask for diagnosis?
No, and we didn't ask for
No,
diagnosis.
but I mean,
No, she
so
didn't.
you say there's this theory.
Implicit.
It was implicit.
It was implicit. Here are all her problems. Here are her
But
symptoms.
Kevin, there was a question on direct about, are there different kinds of depression? And she said, yes, there are. But really, I've looked at this a few times, and I just direct me if you could. The cross-examination begins after the stuff about, do you know what malingering is? Describe how she came across and her demeanor during your first meetings. And then you get all this. She was shut down. You couldn't get a question out of her. She was upset. She cried frequently. She didn't sleep. She didn't eat. She was afraid to go anywhere. She was depressed. And then next page. And what are the symptoms based on your expertise that you've already described about someone who's been sexual? And then she goes through the same things. Did I miss it, or is this same kind of eliciting of those symptoms, and it could be, was that also elicited, those same things? How did she come across? What was her demeanor? What did she manifest in terms of symptomatology? Indirect. Did those things come out like that?
Well, certainly the presenting symptoms came out that she was anxious, that she was depressed, that she had agoraphobia, that she had trouble sleeping. All of those things came out on direct, certainly, which are.
Let's say that was enough. Let's say that they at least somewhat coincide. Don't Trowbridge and Richardson in those cases say that if you're going to call someone who's a treating physician, and we've got this situation where you have someone now also converted to an expert, would it have been appropriate just to ask what her expertise tells her about symptoms with respect to sexual assault victims? And just go without saying, well, first tell me what she did and now tell me what those symptoms are.
I suppose you could do that, but I
Isn't
can't
that what they
believe
say?
that repeating, that the fact that the prosecutor elicited the list of her demeanor, which is perfectly appropriate to question the therapist further about her demeanor and elicit all these symptoms. I don't see how that could make the difference in the follow-up question. The real question, and I acknowledge that it's a question, is was it appropriate for her to to then talk about the specific attributes or general attributes of sexual assault victims. But I can't believe that any error can be found in asking her about her demeanor. And it wasn't leading. It was an open-ended question that elicited that whole big paragraph from the therapist about her demeanor. And a lot of it was repeated, if not all of it. And the parts of it that were not repeated were not prompted by the prosecutor. So I just can't believe that makes a real difference in the analysis. I think the only question is really whether it's appropriate for her, with that background of what's happened beforehand altogether, to then talk about typical attributes of sexual assault victims. And my position is that in the circumstances of this case, it was appropriate.
So, but I'm not sure if you answered this question for Justice Spina, but would it have been appropriate for the Commonwealth to have called the same witness and to use her both as an expert and a fact witness?
It's hard to, you probably didn't think I answered it because I waffled, which is just to say that I think all of these cases are really a case-by-case basis, and it's hard for me to say in every case, in every circumstance, it would have been inappropriate.
But let's assume that, I mean, of course,
Didn't.
we know, I know that, but we know what this witness testified to. And would you be able to have elicited through this same witness both her expertise in the symptoms of sexual assault victims and her evaluation of the symptoms of this alleged victim?
I think we certainly wouldn't have done that.
Okay, so I guess then the question
As to whether
is,
it's possible that it would.
what opened the door, what opened the door to allowing you to do so when they didn't offer her as an expert? I guess that's the concern I have.
I think it is purely the scope of effective cross-examination in questioning an individual to develop alternative explanations for something that she has testified to on direct examination. And I think that in addition, I mean, there are a number of factors which are discussed in my brief, which I think affect whether or not it was unfairly prejudicial to the defendant, apart from it just being appropriate.
But what was the explanation that was given for which the prosecutor sought an alternative on cross-examination?
It was the idea that here were all the victims' reported problems at school, and here was her emotional trauma. And for
But
20
that's-
sessions, that's what we talked about.
But isn't that going from an explanation by the victim during, or the alleged victim during therapy, and then an explanation by the expert as to what was really going on?
Is the question, since she hadn't rendered an opinion, I think this is the question.
Yeah.
I
Since she
agree.
hadn't rendered an opinion in direct, that in my professional blah, blah, I think that, her symptoms were caused by bullying. She didn't say that.
It's true. It's true. She didn't say that. But I think that the link was clear, that the defendant wanted the jurors to draw. Here are her reported problems. Here are her symptoms. End of story. No mention of sexual abuse. In fact, she denied sexual abuse. And she wanted jurors to draw the conclusion that her problems at school were the cause of her emotional turmoil. And I agree that there is no explicit opinion, but I think that the impression that she intended to create was clear in that case.
Thank you, counsel.
Thank you very much.